welcome to the courtroom. While the new companies law continues to be in transition with some provisions yet to be notified, today on this edition we take up the issue that has come to the forefront in the recent past. The invoking of Section 396 of the Companies Act 1956, which continues to be enforceable even now. Now, Section 396 empowers the central government to provide for amalgamation for public interest. And the question we are asking, are the concerns of invoking of Section 396 valid? Is the scope of the provision way too wide? Is the concept of limited liability of a company getting jeopardized? And much more. We have with us a panel which includes experts from all walks of life to look into this issue from all perspectives. Joining me is economic analyst Pranjal Sharma here with me in the Delhi studio. Also, to get the legal perspective, we have with us Amit Nayak, founding partner at Nayak and Company, and Mr. Prakash Chaturvedi, MD and CEO of NSEL, also joining me here from Mumbai. Thank you so much, gentlemen, for joining me here on this special debate. Let me start with you, Mr. Chaturvedi, first. You have already been raising concerns and have raised, of course, the objections as far as this entire invoking of Section 396 is concerned, and especially because you're dealing with that situation at this point in time in certain aspects. Let me start the debate with you and to get your concern for us to help a holistic debate and to understand the issue from the crux. Mr. Chaturvedi.
Thank you for inviting me. I have to start with trying to establish few things first. Number one, it's clear, no debate required, that money has been appropriated improperly by some people. That is number one. Number two, it is also very, very clear where that unfairly appropriated money is lying. We are calling them defaulters. Number three, this entire saga, you can call it a fraud, you can call it a scam, no matter what you call it, has four dramatis personae. One is these defaulters, those guys who are sitting on the money, not returning. Number two are the trading clients, those apparently whose money has been taken away by these defaulters. Third are the brokers who have been the go-between in trying to facilitate these kind of inappropriate transactions. Fourth is NSEL, the platform which has been used for this kind of improper money transactions. Section 396, to my mind, is not appropriate and required to be invoked out here. To my limited understanding, I believe and I think this section is to be used only between consenting parties. I don't know if this section has ever been used in a case where you are forcibly in a hostile fashion asking two parties to merge. You cannot enforce a marriage. This section does not only entails a satisfaction of the government. Now it is something like a marriage counselor. He is satisfied that two parties want to merge. He will facilitate that kind of marriage. There is no investigation required by that particular marriage counselor. Now here is a forced merger. You are forcibly asking one party, when 100% of the stakeholders of that party are opposing it, to merge with another party where 100% of the stakeholders of that party are also opposing it, just by way of an executive order. You have not waited for the investigation to be over, you have not waited for the trial to be over, you have not waited for the judiciary to apply its mind. Bypassing all of this, you want an executive order to implement this merger.
Mr. Chaturvedi, therefore my question is, since the matter is still under investigation, without getting into the nuances of the specific case, if you were to legally, as you would be legally questioning as far as why Section 396 were invoked, the key concerns that you talk about is that the consent of the two parties, you believe, should have been taken. But in terms of, do you think that the concern is emanating more from the fact that there was, of course, shareholders' disapproval that came, and that also included some of the public shareholders?
Yes, so they have all together disapproved of this merger. The legal machinery will take its own time, and by the time a judiciary verdict is given, it will be too late for any kind of rollback of any injustice to be done. That is what that is where
All right, let me
our
bring
concerns
in-
are coming from. If at all these applications, these sections were to be applied, please start applying this where the illegal, ill-gotten money is lying.
All right, Mr. Chaturvedi, I'm not going to get into too much of specifics out here, but let me get in Amit, and to understand Amit from a legal perspective, let's look at what has happened so far as invoking of Section 396 is concerned. There have been 4 cases that one has seen ever since 1956 Act where this section has been invoked. The most famous that everybody remembers, of course, is the Indian Airlines and Air India merger. Most of them have been, of course, with regard to public enterprises really coming in together, and therefore the government stance and this whole question or debate of invoking of Section 396 never came before until, of course, we've seen the recent past private entity really coming into the picture. Your first comments in terms of how valid is the concern do you think is going to be in the overall corporate India understanding of it with regard to what has happened in the recent past, and keeping in view that there have been 4 such cases ever since 1956?
Well, let me preface my discussion by saying 3 important points. In independent history of corporate India, this is the first time that such an order has been promulgated. Second and most important, this is unchartered, uncannibalized, arbitrary, unconstitutional, and of course unconsensual. It's not consensual. So this is the first time that you are foisting a liability. Now, what is the ingredients of Section 396? How is 396 supposed to be used? And what is the purpose and purport of 396? That's the root of the matter. As far as 396 is concerned, the prescription of the section is very clear. It has to be that the central government is satisfied. That satisfaction cannot be subjective, it has to be objective. It must be essential and it must be in public interest. Now, these are the ingredients of Section 396. Even in the case of government companies where hitherto before it has been utilized, right, even before this, even in that case, the government, the MCA themselves, had a circular which said that 100% shareholder consent is required and 90% creditors' consent is required. So here this is unconsensual. Now, if you look at a scheme under 391, 394 of the High Court, that itself goes through an approval and a process. In this case, it's completely arbitrary. Now look at the stated purpose of the draft amalgamation order.
So, Amit, are you trying to say that as far as the Section 396 is concerned, the provision and how it works out that there has to be a consent of both the parties? It is very clear in the law. There is no ambiguity with regard to that. Is that what you're saying?
No, that's not what I'm saying. I'm saying the purpose and the purport of 396 is very clear, that it has to be subjective, it has to be objective satisfaction of the government. Now, what is the stated purpose in the draft amalgamation order, and whether that purpose that the government is stating falls within the prescription of 396. The substantive challenge to 396 that it's unconstitutional is a primary issue and must be not utilized. But before I go to that, whether the stated purpose of the government, whether the stated purpose that they've stated in the draft amalgamation order is within the parameters and the prescription of 396. What has the government stated in the draft amalgamation order of 21st of October? The government has stated that the purpose is to recover money. That can never be the purpose. That is not what 396 prescribes. Suppose if there is an income tax issue, suppose if there are monies due or payable, there's a judicial process. Will you invoke 396? So on the face of it, the invocation by the government and the MCA is on the basis of the stated purpose for recovery. They improved their stand in 397 when they filed a petition under 397 in the company law board. They say that the stated purpose is to recompense the victims. That cannot be, and that is not the purpose or the prescription under 396. Now let's come to the real issue. The real issue is that ultimately there must be public interest. Is there public interest? What is the concept of a limited liability company? Now see what has happened in this case. Despite the fact their stated purpose is that NSEL is weak and unable to recover, they have completely relied on what the Forward Market Commission has said, and the Forward Market Commission has misled the government. NSEL has got decrees of 1225 crores, which is unheard of in a period of 1 year in our jurisprudence. Despite that, they have recommended this 396 action for the purposes of recovery. How could that ever be the stated purpose under the section?
Amit, I'll have to stop you there and I have to take a break right now. We'll be continuing discussion on the same. I will come back to you on this, but we will have to slip into a short break right now, and we will continue the debate of Section 396 of the Companies Act, empowering the government to provide for amalgamation for public interest. The debate continues in just a bit. Welcome back. We continue to ask what is public interest, and is the scope too large for government to provide for amalgamation between two companies? And let me bring in Pranjal here. You know, Pranjal, it's not been, I'm not going to go into the specific case that we've dealt with in the first half of the show, but I'm going to ask a more larger and a generic question, and which is that there have been in so many, we've seen so many instances when you have subsidiaries may not have done well. There have been issues in various other cases that have come in the corporate India history, and therefore the government to take that responsibility in terms of doing it in public interest. Do you think that the scope is bit too large, and there probably needs more more defined way to figure out as to what really should be the parameters in which it should invoke this?
I think so, absolutely, Priyal. You know, why should a government decide whether two private companies run by two independent boards be merged at all? Why are you doing this? On what basis? What are the parameters? What are the laid down criteria and triggers which will set this out? At a time when India is trying to say that it wants to be a country where industry and entrepreneurs can do their business, create wealth, value and jobs for everybody. You have this fear of the government deciding that, look, just because for some reason one company ran losses, I'm going to force both of you to merge. It's like a shotgun marriage, and one of the guests earlier referred to that as well. So, this is not the way any government policy framework can run when it says that it's willingly inviting investors to play in the economy. Now, there could be a reason. The government has a right to step in, but I think instead of an executive decision taken by a bunch of officers, what is important is to have a policy framework which allows the board to take the decision. The Companies Act has to be changed further, because in the last few years we have seen a further effort on improving corporate governance in the country, and we've had a crisis created by the collapse of companies like Satyam, where the need for independent board, independent directors, ensuring that the auditors' independence, all these are important elements and pillars of creating a very robust corporate governance framework.
The question is that when we talk about a Satyam case, it's considered as an example of how the government has stepped in and worked in the interest for everybody involved.
But even in that case, the government went through a judicial process. There was a judicial process which allowed the government to take, and there again, the objective was to save the company and the interest of the employees. But it went through a long process, so there was no arbitrariness involved. In some of the decisions, the fear is that if you just decide to put this as a sword, that look, if you don't behave, I'm going to force you to merge, I'm going to take over your board, that is not an atmosphere in which you can do it. We've seen that even in the case of Vodafone. How couldn't you decide an issue with retrospective effect? It is not it's a similar case here, where the executive discretion can lead to some level of opacity, where you don't know why you're doing it, you are not accountable to it. So I think ideally what the government should be doing is creating a framework where the board is the supreme body in a corporate entity. Let the board have as much accountability as the government and the policy framework wants to put on board. Let the board decide.
As the government has been already talking about that we don't want to do business.
Absolutely.
We want to just govern.
Absolutely.
And that's where it should, that difference, that that is where it should lie really.
Even boards feel that sometimes they don't have the expertise and the talent enough, so they bring in outside experts. They would bring in some of the experts like the one on the show, legal experts, constitutional experts, who will come and say, look, whether it is correct or not to take a step like this. So empower the board, but the government cannot replace the board's decision making, in my view.
All right, Amit, I'm not not being specific as far as this case is concerned, but overall, if you could help us understand in terms of the way of the fact that public interest is something that has been laid emphasis on in terms of invoking of Section 396. Do you think that is a very wide scope for the government to act upon, or there are already clear definitions and framework in place that ought to have been followed?
Yeah. So let me tell you, as far as 396 is concerned, the word public interest was substituted for the word national interest. Therefore, you have to look at it in that sense. And it hasn't changed. Now, public interest has been sort of promulgated and also decided by courts of what is public interest. The issue here is slightly different. The section is very clear that this has to be used in the most severest of cases, where it is of paramount importance, not for the purposes of recovery. See, ultimately, legal jurisprudence really says that you cannot destroy the juristic entity on the basis of some other stated purpose. Here there is no public interest except private interest that is being served. The government, on the basis of a Vodafone or otherwise, will have to come to a conclusion. Has the government, while invoking this section, independently come to a conclusion other than relying on what the FMC has said? I know you're not talking specific of the case. Now, if you look at the section itself, it is very, very clear that this has to be used in the rarest of rarest cases. And even in the case of government companies, consensually there is a circular that the MCA themselves have promulgated. Therefore, this cannot be unconsensual. This should not be arbitrary. This must be used judiciously, not capriciously. That's the prescription of the section. If you start invoking 396, assuming, like I said, there's an income tax liability, there is some recovery, there is something else to be done, are you going to resort to 396? That is not the purpose and the purport of this section and can never be. Therefore, according to me, this really sets a wrong precedent in India. Today, when you have foreign direct investment happening in India and the Make in India concept, by allowing this section to be invoked, this is not about the NSEL scam, this is not about FTI. This is about what corporate India's image is going to be, and the law is very clear. If you are going to destroy the principle of Solomon versus Solomon, I don't think you're going to have people to come here and stay. As far as the other gentleman who said on the board, I think to come to the stage of the board is much, much later. The question is, will the government exercise this discretionary power that is vested with it for this purpose? And can it do so? And must it do so? That's what begs the question. I would say that there is no public interest. Public interest is very clear that it is akin to national interest here. Whether there is something really in that sense, there are only 781 people, of which there are only 10 people worth 5 crores of money. Is that public interest, and can that ever be public interest? Will you do this for every company, whether it is Kingfisher? What is the precedent that you are setting?
Okay, and therefore the scope is larger.
True. So I just wanted to add to what Amit was saying, that checks and balances are a fundamental construct of our economy and the democracy as well. So to prevent the government stepping into the corporate domain and to prevent the corporates to step into the consumer domain and the shareholders, everybody's interest has to be balanced. In that situation, checks and balances are very important. So in this case, in this particular case, 396 does not give the impression of a countervailing balance or a check on somebody who wants to wield it. So it is like a bullet to your head. There is nobody to stop you. So what the government needs to do is to remove the fear in the minds of corporates and say, look, this will not happen unless step A, B, C, D are taken and especially bring a larger ecosystem into the place, bring the judicial process into the place, so that an independent person can also say, look, now I think it is a rarest of rare case for you to take the step.
All right. Okay, we slip into a short break again in this debate, but it will continue after a very short break. Welcome back. The Old Companies Act, Section 396, which we are debating, will find its way in Section 237 of the new Act as and when it gets notified. But the provisions empowering the government remain as is the case currently that we are seeing and discussing. So is there a more prudent discretion that is required in terms of how Section 396 or thereafter Section 237 is invoked? Let me get in Mr. Chaturvedi, your comments First, sir, of course, as far as you've expressed your concern that, you know, there has been an arbitrariness in terms of invoking of that section, but going forward as well, that section remains as it is to empower the government. What do you think should be the next step forward in terms of, you know, the checks and balances, as Pranjal also put in earlier?
I mean, what I have to say, the only step next, or whichever, the government machinery has to go and lay their hands, get money out from the defaulters. Try to understand, the more you delay, the more the recovery will be less and the more difficult it's going to be. If the objective of everything that the government is doing is recovery, if the system wanted to recover money, by now 85% of the money could have been recovered by just 7 identified defaulters. Why anything of that has not been done so far?
That's what my question to you was slightly different. Let me get in Amit here. Amit, I want to understand from you that the provisions that Section 396 is going to be the same as far as what the new companies law offers. And so therefore, do you think, as Pranjal pointed out, in terms of the checks and balances, what really needs to come into the picture as and when the new law comes into play?
Yeah, so let me say this, that Section 396 doesn't have any guidelines as to its exercise and how the checks and balances will be done. I think they need to frame guidelines. They were not existing, they are not existing, and they must exist. There must be a guideline which sets out the checks and balances as to what are the bases on which you will exercise 396. There isn't any guideline, because you must understand that 396 is an exception to 391 to 394 when the court exercised judicial power. So therefore, when you're exercising an executive fiat and you're using a discretionary power, it is uncharted if you don't have guidelines. Therefore, I agree with the gentleman who just spoke earlier that there must be guidelines, that the government, the legislature must prescribe that guidelines, or in delegated legislation we must have what the guidelines should be.
All right, Amit, absolutely running out of time. I have to give the last word to Pranjal. Pranjal, what is your comment in terms of, you've already put the base as far as checks and balances is concerned. What else needs to be done by the government?
I think the government has to create these guidelines, and until those guidelines come into the picture, there should be a clear understanding within the government that such steps of forcing mergers between two companies which are board run should happen only after a certain due diligence, or if nothing else, a judicial endorsement. Let the government, if it's in doubt, seek guidance from the judiciary, let a judicial process follow, and let that come in, so that it is not left to one officer who has the power to sign off on this merger order, which in many ways is completely illegal.
All right, well, we'll have to leave it at that. Absolutely run out of time. Thank you all, gentlemen, for joining us on this debate. That's all we have time for in this edition. Thank you so much for